Hey there, I'm estate planning attorney Paul Rabelais, and in this video, I'm going to discuss a strategy that surprises a lot of people, especially older couples who are worried about nursing home costs. All right, so for some couples in their 80s, changing their wills and their beneficiary designations could protect half of what they've worked for from being lost to nursing home expenses. Let me give you an example. Let's say John and Mary, they're each 86 and they're in declining health. They have a $700,000 estate. Let's say they each own half of that. So John owns $350,000 and Mary owns $350,000. And they know they live in an area where the monthly nursing home expenses are $12,000 per month. They are worried that if one spouse dies and the surviving spouse needs nursing home care, they'd be wiped out. And like most couples, their wills leave everything to the surviving spouse. And John's will says, for example, when I die, I leave everything to Mary, but if Mary predeceases me or Mary dies before me, then when I die, I leave everything to our kids. That's the way most kind of quote unquote simple wills are written. Feels fair, feels natural, makes sense, until you factor in long-term care, nursing homes, and Medicaid rules. Because when John dies, leaving his $350,000 to Mary, Mary now owns the entire $700,000. And if she needs long-term care in a nursing home, she'll have to be forced to spend it all down until she has less than $2,000 remaining before Mary can qualify for long-term care Medicaid eligibility. So here's an alternative plan, and you can let me know in the comments whether you think it makes any sense, but here's where it can get a little bit interesting. So let's say John and Mary change their wills. They change all of their beneficiary designations on their IRAs, on their life insurance, and any other beneficiary designations. And if they have one, they change their revocable living trust so that when the first spouse dies, all of the first to die, all of that spouse's share goes directly to the children, not to the surviving spouse. So for example, if John dies first, John's $350,000 goes to the children, not to Mary. In fact, more may go to the children when John dies if the bulk of John and Mary's savings are in John's IRA. So if Mary needs long-term care, at least half of the estate is protected because when John died, his estate didn't go to Mary, it went to their children, and so Mary's just left with the assets that she owns. Now you might be thinking, wait, isn't there like a 5-year look-back rule for gifts and quote-unquote uncompensated transfers? Yes, there is, but for some older couples, the family often feels it's too late to transfer all of the assets in their late 80s when they're in declining health. For some families, it doesn't make sense to transfer all those assets out of their name to simply start a 5-year ineligibility period for long-term care Medicaid. But when someone dies and leaves assets to others at death, either through their will or through beneficiary designation or through a revocable living trust, that's not considered an uncompensated transfer that would trigger this 5-year look-back rule or this 5-year penalty period. So that's why a couple, perhaps in their late 80s and in declining health, can use this estate plan adjustment to protect half of what they have without having to wait 5 years. So this obviously works best when the kids are cooperative, when the children agree to set aside that inheritance and agree to use those funds for Mary if she needs it. Everybody's got to be on the same page. So this strategy might make sense for an older couple in declining health with a modest estate, where both spouses are comfortable leaving assets to the children instead of the surviving spouse. And it works well when there's a kind of a strong likelihood that the surviving spouse will need long-term care because there's no one else in the home after the first spouse dies to provide that care. All right, so in the comments, I'd love to hear your thoughts. Does this strategy make sense for an older couple with a modest estate? Or should they just continue leaving everything like it is and leave everything to the surviving spouse and just simply kind of spend it if necessary, if that surviving spouse needs long-term care in a nursing home. Okay, hope that helps. We'll see you next time.